New York City tenants have more rights than tenants anywhere else in America, but New York City tenants are also shockingly uneducated about what those rights are. A right you don't know you have is the same as no right at all. That's what this podcast is here to fix. Come along with a lawyer who's been doing nothing but landlord-tenant law in New York City for 30 years and take a deep dive every episode into important recent cases and new laws. This show proudly covers stuff that is hard and boring, which is why nobody else is covering it. But it's what you need to know to protect your home, your money, and your peace of mind. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is Learn to Live Better, a housing law podcast. Rent-stabilized apartments are good things to have if you are a tenant. There are 1 million rent-stabilized apartments in New York City, and if you want to know more about the details about them, we've covered this on several of the episodes. So just look in the back catalog. Just go to the website for the podcast, and I have a page on there now with all the titles, so you can just do a Control F and find the topics that you're looking for. But a rent-stabilized apartment is a good thing to have. Right now, as I'm recording this, the rent increases available, according to the New York City Rent Guidelines Board, for rent-stabilized apartments for a 2-year lease and a 1-year lease. And remember, the tenant gets to choose 2-year or 1-year renewal. The 2-year renewal is 0% as I record this, and the 1-year renewal increase is 0% as I record this. So 0 and 0 are pretty good renewal levels if you are a tenant. Also, a rent-stabilized tenant can only be evicted for a very good cause. It's very hard to evict a rent-stabilized tenant, and rent-stabilized tenants have other advantages over other types of tenants. If a rent-stabilized tenant needs repairs, they can not only call 311, call HPD, do an HP case, but a rent-stabilized tenant also has the ability to utilize a procedure at the New York State Division of Housing and Community Renewal to make a report of bad conditions. An inspector will be dispatched. Your rent level will be rolled back and frozen there until the work is done. So it's very good to be a rent-stabilized tenant. But with this privilege of having a rent-stabilized apartment also comes greater responsibility. A rent-stabilized tenant is required to maintain their apartment as their primary residence. Primary residence. The apartment must be your primary residence. Rent Stabilization Code 2524.4. It's built right into the definition. You have to maintain the apartment as your primary residence. Now, what does that mean? There is a complicated legal definition that has developed out of the case law about this area, about what is primary residence. But what I tell my tenant clients and my landlord clients, and what I tell everybody, here's an easy way to think about primary residence. Your apartment is your primary residence if it's where you really live. Do you really live there? Your apartment is your primary residence if it's where you really live. And that's not such a simple conversation. That's why there have been tons and tons and tons of cases over the decades on this topic, and I have read them all. And from those cases, and also from just representing tenants in these types of cases and getting demands from the landlord's attorney and rulings from the judge about what a tenant has to produce to prove that the apartment is where they really live, I've developed a list of things, of types of evidence that tend to help a tenant or hurt a tenant. It could go either way. It depends on what the evidence shows, but types of evidence that courts require you to produce to show where you're really living. That's what I've put into this booklet. I've made a 29-page free booklet, again, that's on my website. It's itkowitz.com, itkowitz.com. There's a booklets tab. It's the first booklet under it. And the script for today's material is just me covering the booklet with you. Why are there so many of these cases? Let's just talk about that for a minute. These are the big cases in the rent stabilized area for a couple reasons. Number one, New Yorkers are big city people, they're worldly people. And by definition, they're therefore often itinerant. They travel. They're not afraid of the world. They want to see the world. They have places to go and things to do. Especially, this is applicable for my Broadway podcast network audience of artists, all kinds of artists. Artists, creatives tend to travel for their work and for their passion. And lots of people travel for business, and lots of people travel for the sake of traveling and seeing the world. And then there's also relationships. People travel to live with significant others, experiment with relationships, to take care of sick relatives. There's a million reasons to travel, and New Yorkers move around. If you're in your rent stabilized apartment 365 days a year, or if you take a 2-week vacation here or there, this isn't your issue. But for anybody who's on the move on a regular basis, gone from their apartment from weeks or months or years, on and off, always moving, or having a certain period of time where there's a big change and you're somewhere else, you are who has to worry about this. And I get so many calls on this. Enough calls that I made a 29-page booklet. And it's a big part of my practice. I always have a bunch of these cases going on. And also, I think the other reason these cases really resonate and courts take them very seriously is because if your apartment is not your primary residence, then what you are doing is bad. It's not only bad vis-a-vis the landlord or the government because you're breaking a regulation, but it's bad because you're depriving another New York City family, another New Yorker, of the opportunity to have that rent stabilized apartment. If you're just putting an apartment aside as a pied-a-terre for when you come into the city, or as your office when you come into work, or you're not sure what you're doing, you're living somewhere else for now, but you might want the apartment later, or if you're profiteering, illegal Airbnb, you're making a big profit on it, all of that is wrong. And the courts take that very seriously. They will scrutinize where you really live. So I think that's why the cases are so ubiquitous. The booklet does not exist. This episode does not exist to help people who are otherwise cheating and doing this, or just holding the apartment to rent it to somebody else. Obviously, I'm not interested in helping anybody with that. I got a call recently from a guy who he thought that he was subletting from another struggling artist. And he found out that that wasn't the case. The person who he was subletting from was somebody renting the apartment who hadn't been in the city in years. And that person was charging him double what he was paying the landlord. So they were profiteering. If you have a furnished rent stabilized apartment that you legally sublet, you can get a 10% markup for it. You can't make money on it. And that's the rule. And because of this, the guy was very angry. He's like, I'm subletting from somebody who's basically scamming the system, and he's charging me twice what he should be charging me. And I told the guy, I said, look, you have a nice overcharge claim against that rent stabilized tenant who is essentially your landlord who's cheating you. I don't know whatever happened with it, but the point is, I get those calls all the time. This booklet and this episode are not designed to protect those people who are depriving other New Yorkers of stabilized housing. And indeed, nothing I say today will help them, because the point is, eventually the system will catch up with those people. But the other thing this booklet isn't really for is if you've already been sued, this booklet is not a substitute for you hiring a qualified attorney to protect you. It can't hurt for you to read it, to help you work positively with your attorney. But really, this booklet and this podcast are designed for prevention, trying to help people who are really using their apartments as their primary residence, who they're gone for some reason, work, a sick relative, they have a summer home, whatever it is, and the landlord has their eye on the apartment, as we were talking about in episode 59, and you need to just protect yourself. And by understanding what goes into these cases, you can be proactive about how you make choices about any number of things in your life that you don't think have any impact on your apartment, but actually do. And that's what you're going to see in this episode. And that's why this is such an important episode. Now we are going to start by talking about some procedural aspects of these cases. Now, again, this isn't about me trying to help you navigate one of these cases without a lawyer. That's not what we're doing. What we're trying to do is help you understand how the cases work, again, for prevention. So stick with me here. In later segments in this episode, we're going to talk about substantive defenses to show how you really do live in the apartment. But for this segment, we're talking about a procedural defense to this, and it's pretty meaningful in this context. Stick with me. Non-primary residence is not a reason to terminate your lease. That's important. And let me say that again. Non-primary residence is not a reason that a landlord can terminate your rent stabilized lease, but it is a reason that your landlord cannot renew your lease. Wait a minute. That sounds like a distinction without a difference. Oh, they can't terminate me, but they cannot renew me. Well, what's the difference? There is a difference, and I'll tell you why. Because renewal with rent stabilized leases gets done a very specific way. Between 3 and 5 months, between 90 and 150 days before the end of your rent stabilized lease, that's a renewal window when the landlord is supposed to then, in that 60 days, send you an offer for renewal. That's where you'd get your offer saying, hey, 0% and 0%, which is what it is right now. But whatever it is, sometimes it's 2% and 4%. Or 3% and 5%. That renewal and all the paperwork that comes with the renewal comes between 90 and 150 days before the end of your lease. And it is in that renewal window, 90 to 150 days, that renewal window is where the landlord would also be telling you, hey, wait a minute, no 0 and 0 for you, or whatever it is. I'm not renewing your lease. And I'm not renewing your lease because I suspect that you're not living in the apartment as your primary residence. And here are my reasons for thinking that. That would be when you get that. So it's interesting because you can only be notified of the non-renewal in the 90 to 150 renewal window. So if the landlord misses that window, then the landlord can't refuse to renew you for non-primary residence. And here's why this is so important. I get calls from tenants all the time that say, my landlord hasn't renewed my lease in 4 years. I've not gotten any offer for renewal. And I saw my landlord in the hallway the other day, and she was saying, hey, you don't really live here. I'm so afraid. I really want my lease. Michelle, can you get me my lease? Because I really do live here. And I'm like, whoa, wait. In rent stabilization, the lease protects the landlord so much more than it protects the tenant. A lease is really for the benefit of the landlord. In the rent stabilization context, when you don't have a lease, your landlord can't raise your rent. They can't bring you to court for non-payment. They're really paralyzed. It's a bad thing for a landlord not to have renewed your lease. And if your new lease term hasn't started, well, it can't end. And if it can't end, you can't get to the 90 to 150 before the end. So the window is closed. So there's really no one safer out there than someone who doesn't have their rent stabilized lease renewed. You're golden. Your landlord can't get to you. So if a landlord walked into me and said, hey, I've got this tenant and they're non-primary residents. And I'll say, okay, show me the lease. Well, because of that, I didn't renew their lease. They haven't had a lease in 5 years. Well, I have bad news for that landlord. The first thing you have to do is make an offer to renew that lease. And, the tenant has 60 to 90 days to get that document back to you. So you're now probably about 2 years away from being able to start one of these cases. So not renewing the lease is in the tenant's favor on these types of cases. Now think of how powerful that information I just gave you is, because we're not even getting into the weeds that you're going to see later in the episode about how you prove where you really live. This is a procedural situation that really will very much protect you, that you should be aware of. So before you start calling up a lawyer or calling up your landlord and badgering them for that lease renewal, if it's sketchy about where your primary residence is right now, that's not a good thing for you to be doing. That's a sleeping dog that you should let lie. And just knowing that is some level of more power and control over what happens next. Okay, so next we are getting into the substantive part about this. Assuming your landlord is properly refusing to not renew your lease? What are the kinds of things that you should be thinking about? And ultimately, all of this stuff is what you should be thinking about before you get a notice. You don't want to get a notice. You want to avoid the notice. In other words, you don't want to start thinking about this for the first time once your tenancy is threatened. But first, let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it is terrible because I am asking you not to contact me. This podcast is not a commercial for me or my law firm. This is simply one of the podcasts that I always wanted to make. What I would like to hear from you on is what topics you would like me to cover. My email is in the show notes. In this segment, we're taking a deep dive into the booklet that I've written and made absolutely free for anybody who wants it, called How to Protect Your Rent Stabilized Apartment in Non-Primary Residence and Succession Cases. That's available on my law firm website, which is itkowitz.com, itkowitz.com. Under the booklet section, it's the newest booklet. Absolutely free. You don't even need to give me your email address or anything like that. And I'm picking up on page 13 of that booklet, and we're covering public records and personal documents that you would be asked to produce by the landlord's lawyer and by the judge if you had a non-primary residence case against you. And again, what we're focused on here is prevention. We're not focused on a court case, but to prevent a court case, we have to think about a court case. So these are the documents that you would be asked to produce if you were in a non-primary residence case. When I represent a tenant that gets a notice of non-renewal, if a tenant gets that and comes to me and I'm their lawyer, what I'm doing during that period of time is not just sitting there twiddling my thumbs. I'm compiling with the tenant all of this evidence, hopefully to show that the apartment has been their primary residence. And what I do, my tactic is I always will send that information or offer to send that information to the lawyer for the landlord way ahead of time. And I basically offer to do the discovery that they would have in the context of the eviction case before there is a case. Why would I do that? Because I'm trying to talk the landlord down. I'm trying to demonstrate to the landlord and their counsel that this isn't the right case for them. They're not going to win it because look at all these documents I have, or all these other factors, all these other things I can bring in to show that the tenant actually has been maintaining the apartment as their primary residence. Does that work? It works 50% of the time in my practice, just to keep the case from being a case. But if the case does become a case, then I'm well equipped to deal with the case way ahead of time. So these are the documents that courts will ask you for if a case does start. Where am I getting this from? I read every case. I read every non-primary residence case that comes out of the appellate courts, frankly, that comes out even and especially of the lower courts. And over time, doing many of these cases, having landlords demand these kinds of documents, I have developed lists, and looking at all these cases, I just have a very long list of things that you might be asked to produce if you are being sued for eviction over the issue of where is your primary residence. Now, I'm going to tell you before we even get started, this is a very invasive list of things. It's a lot of information about your life. It's about your personal life because it's about where you live. And a lot of people, when they find themselves ensconced in one of these cases, find it very, very intrusive. And I would say this, a lot of these documents, if they have to be produced in the context of one of these court cases, a lot of things in the documents can be redacted. So if it's a bank statement, you can redact how much money you have in the bank. But the bank statement might be needed to show where you do your banking, because where you do your banking has a relationship to where you live. If your bank account is in Sacramento, California, and has been for 3 years, well, that tends to prove that New York City is not where you're living. So that kind of thing. So let's just go through this list. And again, I'm pulling everything on this list is on the list because I've either been asked for it by opposing counsel, by landlord counsel, or I found it was asked for in a case. All right. Anything to do with tenants' vehicles and driving. So the tenant's driver's license, motor vehicle registrations, and that's not just for actually cars. It could also be for boats, aircraft, motorcycles, the vehicle's insurance policy. This is a big one. A lot of times people will leave their car at a summer home in, like I said, the Jersey Shore, because something about their insurance is cheaper if it's outside of New York. But insuring your vehicle as if your vehicle is permanently stored in another state, that doesn't look good for saying that your vehicle is in New York where you are living. Parking permits issued to the tenant. So if you have a 365-day a year special parking lot that you're paying for out in Suffolk County, that might tend to mean that it's less likely that you actually live in New York. Easy Pass. Things like Easy Pass will show where your car has been. And then purchase, lease, rental agreements, rental car companies, all that kind of thing. Tenants' taxes. So obviously your federal, state, and city tax returns. If you're saying on your tax returns that you live in Florida because they tax people less than New York, well, that's going to be a strike against you when you're trying to convince a court that you actually live here in New York City. And then Internal Revenue Service forms like W-2s and 1099s. Obviously, if you're getting a tax form from an employer in Indiana, might mean you work in Indiana, unless you're a remote worker living in New York, working in Indiana. But again, that you could establish through other means, but they're going to look at your taxes. They're going to look at your vehicles. They're going to look at your taxes. What's next on the list? Tenants' telephone and internet. So bills for cable and satellite usage, subscriptions that you have. Are you using the apartment or are you using some other address for some other home? And cellular telephones, all that kind of thing. So telephone and internet. Your utilities. They're going to look at your utilities. So they're not only going to look at where the bill for your utilities are, but they probably are going to look at usage. So usage on, for example, your electricity. They will call in a representative of the electric company and have that person testify to how much electricity is being used in the apartment. And if it's a minimal amount that kind of shows that, well, no one's living there, maybe this is enough electricity to run a refrigerator, but this isn't electric that's consistent with a person living in the apartment, that testimony will be procured by the landlord and will be allowed in. So they're going to kind of have an idea of whether you're there or not and how much you're there or not by your utility usage. Your mail forwarding, they're going to look at that. So if you've forwarded all your mail from the apartment for 2 years to Colorado, where you have a second home, then it's going to tend to prove that the apartment isn't your primary residence if you've had all your mail forwarded for a couple of years. Tenants' voter registration. Obviously, your voter registration is going to be important. If you're registered to vote in another state, it's going to tend to prove that you don't live in New York City. Tenants' jury service. That's another one they're going to look at. Your education and your career. I mean, obviously, this is a very obvious one. So pay stubs, earning statements, W-2s, 1099s, pension statements, Social Security statements. They're going to look if you're away for educational purposes. So if you're away because you're a full-time matriculated college student, then the apartment is still your primary residence. But other kinds of business records for any business that you're involved in, that you're a principal of, or that you maintain any ownership interest in. Employment contracts, your professional licenses. So if you are a lawyer and you are only professionally licensed in Arizona, not in New York, and that's how you make your living is as a lawyer, well, that tends to prove that you live in Arizona and not in New York. Memberships in professional organizations. So if you're a member of the Nevada Bar Association, but not the New York Bar Association, and you're a lawyer, that tends to prove that you live in Nevada and not in New York. And calendars. They will ask for calendars and that kind of thing. So you might have a master calendar at work that shows where you travel for business. That actually can be helpful to you, because if you're a salesman who's on the road 6 months of the year, and the reason you're not in the apartment is because you're being deployed by your New York City-based company to go to different states for a week here, 2 weeks there, or Europe or Asia or wherever, because you're a traveling salesperson, okay, that calendar can actually be pretty helpful because it's explaining where you're deployed by your New York City-based company to travel for business. I know a lot of people who are on the road an excruciating amount of time for business. They're also going to look at any documents related to your immediate family, marriage certificate, divorce decrees, birth certificates, school records of your kids. I once had a case where the tenant in the same year winterized her home in Nassau County on Long Island and moved her child to be an elementary school student in a Long Island school. Well, what does that say? It tends to support that you don't live in a New York City apartment anymore because your child's going to school in Long Island at the same time you winterized your house in Long Island. Real property, that brings us to real property in the tenant's name. So if you have deeds for other houses, now a lot of people have deeds for other houses. I see this all the time. A house in Florida, house in upstate New York, house in the Hamptons, even. People have houses other places, deeds in their name. Whether or not that's a summer home or a vacation home, or whether or not that's where your primary residence is, again, all this other stuff flushes it out. So they will look at anything related to the other property, including mortgages, insurance policies, tax bills. That's another thing. There's something I remember was big. Everybody who owned a house in Florida, if you say that that's your primary residence in Florida, you get some kind of Florida homestead exemption. I'm making that up. I don't know what it's really called, but it's something, a benefit that's very lucrative for a homeowner in Florida if you actually live in Florida. So people would check the box. Hey, I live in Florida. If that public record is obtained by the landlord, well, it tends to show that you don't really live in New York. Anything to do with tenants' finances, checking, savings, credit card transactions, brokerage statements, Social Security, pension, Medicare, Medicaid, all that stuff will have an address on it. Again, you don't have to show where you go to the doctor, but you have to show where your doctor is. You don't have to show how much you have in the bank or what your credit card debt is, but you have to show where those statements are going. Tenants' furniture. So any bills or records or anything for where you're buying and having furniture delivered or moved. That's huge, obviously. If you had a moving truck, pick everything up out of your apartment a year and a half ago and drive it somewhere else, well, that's tending to mean that maybe you stopped living in the apartment. Your estate stuff, so your will and your powers of attorney. They will also tend, those are documents that are required to have home addresses. That's a big part of this as well. Recreational activities. This is going to sound crazy, but it can do a lot, such as your library card. I mean, do you have a library card for the New York City Public Library System, and do you use that? Or is your library card in Vermont? And then health clubs, gyms, if you can believe it. I mean, look, if you have a subscription to a health club that's on the same block as your apartment, just the fact that you have the subscription in New York as opposed to someplace else helps. But if you can show you frequent it, well, that's great evidence that you're really living in your apartment. Tenant social or religious organization memberships. Again, if you're a full-time leader in your church in North Carolina, then that tends to prove that you don't really live in New York. Whereas if the church in your neighborhood is someplace you've been going for 30 years and you're a leader there, well, that's going to be great evidence that the apartment's your primary residence. I mean, unless they're accusing you of having a primary residence that's in some other apartment in the same neighborhood as yours, then that's obviously not the best evidence. But in general, anything that has your address on it that connects you to the apartment is good. It's the address being connected to the apartment and it's showing you using the apartment because you're getting deliveries there or you're active in your church or whatever it is. Things that locate you near the apartment through usage and things that have the apartment address on it. Your healthcare professionals, again, I once had a woman who it was easy for her to prove her primary residence was the apartment because she's being treated by an oncologist. And that oncologist was right between her work and the apartment. And it was clear that the summer home that they were accusing her of living in, she wasn't there because her cancer doctor was right here. So sometimes that's all it takes is informing the landlord of like, what are you talking about? You know, I have a job in the city. I'm being treated in the city. Yes, I have a summer home, but this is not the case you want to bring. Barbershop and hair salon. So if you're a regular at a barbershop down the block from your apartment, That's something to establish through maybe your credit card records or something. That could be very useful. Any other litigation that you're involved in, that's a biggie. So if somebody's suing you, if a landscaper is suing you for snow removal that you didn't pay for your house in New Jersey, and the landlord finds that, well, that tends to prove you're not living in your New York City apartment if you're litigating over home improvement stuff for your other house somewhere else. And finally, deliveries. Ooh, deliveries are a biggie. If you can show that you're getting, I don't know, what are the delivery companies? Grubhub or DoorDash or Instacart or HelloFresh. If they're coming to your house every week, 5 nights a week, something like that, well, that tends to prove you're living in the apartment. Whereas if you're getting these deliveries somewhere else, it tends to prove something different. Amazon is another one. If you live in your house, you're going to be getting deliveries there a lot. If you live somewhere else, you're going to be getting deliveries somewhere else. All right, so that's the list of documents. In the next segment, we're going to talk about non-document. Well, it's going to have document aspects, but we're going to talk about other things that tend to prove one way or another where you really live. So the takeaway on this part, though, is it's two things. Number one, there's a concern about where your address is, where your address actually is. So where's your address on your bank statements? Where's your address on your voter registration? Where's your address on your W-2s? So it's your address. You're using the address of the apartment. But then there's also things that just locate you in or near the apartment. Deliveries locate you in the apartment. Any service where somebody's coming to you, maybe for physical therapy in your apartment. Or like I said, your church is on the same block as your apartment. Things that tend to prove you're really there, like electricity usage and whatnot, plus the address. That's what the documents do. And you're looking to create a solid history of that. And the other takeaways from this should be, okay, I'm tempted to check that box that makes my insurance, my car insurance or my insurance for my second home or whatever, cheaper by saying I don't live in New York. But if you do that, you're risking your apartment. None of those pieces of evidence alone are dispositive, but they're not good. I mean, you might say, hey, look, I checked the box in Florida because I wanted to pay a lower tax rate, not because I really lived there. A judge might believe you, but you've immediately undercut yourself somewhat because you've proven to the judge that you're capable of lying on an important government form. So for your own benefit. So if you're capable of lying on an important government form for your own benefit in that context, maybe you're lying here in court today because saving this apartment is that important to you. It's just not good. In this segment, we're covering other types of evidence that landlords use to prove that you are not maintaining the apartment as your primary residence. If you're following along with me in the book, which is on my law firm website, it's the first booklet under the booklet section at itkowitz.com, itkowitz.com. I'm on page 12. We're going to talk about cameras. It is legal, perfectly legal, for your landlord to have a camera in the hallway of your apartment building. The camera may not record your voice. The camera may not peek into your apartment. It has to be, hopefully it's angled in a way that it's not looking in your apartment. But the camera can see who's coming and who's going, and the camera can be hidden. I'm not here to talk about the legalities or proprieties of any of that. I'm here to tell you that a landlord who really wants you out will understand that a picture is worth 1,000 words. In the last segment, we went through 21 different types of documentary proof that prove where you are or aren't. Camera kind of cuts through all that. If there's a hidden camera and a smoke detector in the hallway watching that you're there or not there, and the landlord works up 365 days of blank, like nobody's going in or out, that could be a problem. It can be especially be a problem if you have a good reason for not being there, like you're taking care of a sick relative in another state. We'll get to that in a minute. But you lie and say, oh no, I'm there. I come back and forth. I've had this where the tenant doesn't realize there's a camera. The tenant tells me one story. The documents seem to tell a story. I put that story in, and then a camera tells a different story. And again, it's undercutting your credibility. So just be aware there might be camera data, and that might have to keep you very honest about where you really are. All right. The next thing I want to chat about is subletting. If you don't sublet, that is a much stronger indication that the apartment has remained your primary residence. If you do sublet, it's a much stronger indication that the apartment's not your primary residence. And I mean, particularly if you didn't get the landlord's permission to sublet. An illegal sublet, that's really, truly going to undercut your ability to hang on to the apartment, especially because you don't know that that subtenant is going to play ball. So you get a notice that says, oh, there's an illegal subtenant in there. We're coming at you in 3 to 5 months. We're not going to renew your lease. You might call up the subtenant and say, hey, I need you out. I need to move back in. I want to fight for my apartment. The subtenant doesn't willingly go, then what are you doing? Looking at evicting your illegal subtenant? That whole process is not going to help you in the non-primary residence case. So I'm very, very down on illegal sublet for lots of reasons. It just brings so much more trouble into a tenant's life. A lot of people say, oh, I have to do it. I need the money. Again, you can only really mark it up by 10%. So it's not a money thing, not legally anyway. So sublet is something that could really sink you. Now, roommate is different. A roommate's someone you live with. You're there when they're there. I can always tell who's a roommate and who's a subtenant. And believe me, there's a complicated there's case law on this. But here's, again, your simple, quick way to tell a roommate from a subtenant. A roommate is somebody who you live with, meaning you can walk right into the apartment. A subtenant is somebody who you've given exclusive possession of the unit to, and you can't just show up. All right, moving on to other categories of proof. Tenants' public social media data. I have so many examples in the book. So I'm just going to go through the examples in the book. This is all stuff I've seen. A New York City rent-stabilized tenant who's an actor and a director wrote and starred in a play in Chicago. He was interviewed by a local paper in Chicago, and he tweeted the article. And in the article, he told the interviewer how happy he was to finally have moved permanently to Chicago. So, I mean, if you're going to give an interview, if you're going to go on X, Instagram, whatever, and talk about your great new home somewhere, well, that's going to put your New York City rent-stabilized apartment in jeopardy. A New York City rent-stabilized tenant was a home improvement contractor. On his Instagram account, he posted pictures of the beautiful Swedish cabinetry that he'd installed in people's homes. The problem was that all these homes were in Western Pennsylvania. Again, showed where he was working. A New York City rent-stabilized tenant posted on Facebook all about her good work volunteering in a soup kitchen every weekend, and she friended her landlord, who was able to see this. The problem was that the soup kitchen was in Boston. So if you're somewhere else every weekend, maybe that's where you are during the week. That doesn't help you either. A New York City rent-stabilized tenant was blogging about her upcoming wedding, which was being held in Virginia. One of her posts talked about how she had plenty of room to host out-of-town guests in the pool house of her spacious home in a DC suburb. So again, your social media data, especially now since so much of it can, also gets posted with a location that shows where you were when you posted it and just the context of it. If you're sharing your life, you're sharing where your life is. And if your life is not New York, that's what you're sharing. And again, I'm not trying to help you scam anybody. I'm just saying these are the kind of things to think about. I'm assuming the apartment is your primary residence, but anything that you're going to put on social media from other addresses, other places, is going to tend to cut against you if the landlord tries to make a play for your apartment on the non-primary residence issue. Okay, moving on to building personnel and other tenants of the building. The super is a lovely person. You tip her at Christmas. She's very helpful, but she works for the landlord. She's not your best friend, and she will throw you under the bus. If the landlord asks if you're in your apartment or if somebody else is in your apartment, the super's going to say so. And so will other tenants. Other tenants will not throw you under the bus if you're not there. Your neighbors will throw you under the bus if you're illegally subletting, because that is not only, again, something that you're doing that's very bad for New York, but tenants don't like a revolving door of people who the landlord doesn't know who they are. So that's a whole other reason not to do that. But I'm just telling you, in general, don't go, if you're spending 6 months of the year somewhere else for some other reason, the apartment is still your primary residence, it's still where you really live. Maybe it's not the best idea to chat up your neighbors and brag about your summer home in South Carolina where you're half the year. Because again, you must assume that the people in your building are talking to your landlord. Private investigators, sometimes landlords, frequently landlords, will hire private investigators to run background checks where private investigators get these subscription based databases for licensed investigators. And it just gives them access to certain databases and more information, especially if they have your social security number. And then they can find out a bunch of other information that may or may not be helpful. I personally don't find the private investigator reports so, earth-shatteringly helpful, but I'm just saying it's another tool that is used against tenants in this context. Now let's talk about tenants' intention to return to the apartment. This is something that is subjective. It's not objective, obviously, it's subjective. Do you intend to return to the apartment? So you might be somewhere else 6 months of the year and say that the apartment is your primary residence. You're in that other place because of you need to go to Florida for your health, or you have a sick relative that needed you for 6 months, whatever it is. The court will look at your intention. So again, let's give some examples. This example is coming straight from an actual case. Appellate term, First Department, 1998. The landlord won this case. The tenant was in a healthcare facility for a year. The tenant made no representation as to his intention to return or ability to resume occupancy. The court held that where there had been a prolonged absence from the apartment, a vaguely articulated intent to return at some unspecified time in the future is insufficient to defend a non-primary residence claim. I'll tell you, if you're in a nursing home and it doesn't look like you're coming home and you're trying to hold on to that apartment for your parent or whatever, again, they're going to look at how likely is your parent to be able to return. If they're on their deathbed and there's no clear prognosis for returning to living home and they need to continue to be in that facility, that's going to be taken into account by the court against you in terms of maintaining the apartment as a primary residence. Here's an appellate term case from First Department, 1987. The court found for the landlord where the tenant worked extensively as a model and actress in California, and she rented a house there for several years. Tenant testified to being in New York 60 to 75 days per year, but claimed that the New York apartment was more furnished than the California house. Tenant regards New York as her home and intends to return when work permits her to do so. Tenant paid New York State and New York City income taxes and had a California driver's license and did not sublet the premises. Nevertheless, the court held, we take primary residence to mean an ongoing, substantial physical nexus with the controlled premises for actual living purposes, which can be demonstrated by objective empirical evidence. To the extent that the tenant may honestly return to New York at some indeterminate time in the future, that's not sufficient to maintain stabilization rights in the face of evidentiary proof that primary residence is lacking. An acknowledged purpose of the rent stabilization law is to secure from eviction during a period of scarcity in rental accommodations those tenants who actively require and actively use their apartments for dwelling purposes. Persons such as tenants herein who live outside New York, but who reserve a New York address for secondary purposes of convenience and occasional use when they visit the city, cannot fairly cloak themselves in the protection of extended stabilized status. That kind of says it all. So, tenants' ability to return. Here's a case, appellate term, First Department, 1987. The court held for landlord where the tenant was convicted of murder and sentenced to 15 years to life, with the premises not occupied by anyone, reasoning that an overriding purpose of the non-primary residence law was to ensure that those New Yorkers using their apartments as their primary residences would reap the benefits of that status, and to alleviate the shortage of housing in New York City by returning underutilized apartments to the marketplace. These legislative objectives will not be served by simply permitting the apartment to remain vacant while the tenant serves a lengthy, indeterminate sentence. That the tenant may subjectively intend to return to the premises if and when he is released from prison is not the determinative consideration. Okay, one more case. This one is First Department, Appellate Division, First Department, 2008. Tenant suffered from a mental illness. Oh, this is a good one. That resulted in him feeling compelled to spend virtually all his time away from the subject apartment. Tenant lived the life of a homeless person in the vicinity of the apartment, but rarely going in. He kept his personal belongings in the apartment and received mail there. because there was no showing that tenant would ever return to the apartment, eviction was warranted. Isn't that something? The courts will also look at longevity of the absence. I mean, were you gone for a couple of months or were you gone for a couple of years? And then the court, of course, will look at the reason for the absence. So there's a lot of good reasons to be away for an extended period of time. Maybe you're caring for a dying relative, but did the relative die a year ago and you didn't return to the apartment? My firm won a case where we represented a tenant being sued for non-primary residence. And the tenant was a tenured professor at a university here in New York City. And his wife was suffering from a terminal illness. And their son was a doctor in Texas, an oncologist at a teaching hospital. So the couple went to Texas to be with their son for the end of the wife's life. And the tenant was gone from the apartment for nearly 2 years. 2 years this tenant was gone, but the apartment was never sublet. The tenant resumed his teaching job at the university when he returned to New York, which was shortly after his wife's death. And we were able to save that home. It was 2 years he was gone. But the point is, he was gone because his wife was dying. He was gone because being in Texas made sense because he had an oncologist son, and the apartment wasn't sublet, and he maintained his tenure and went back to work after his wife died. So longevity is the thing, but so is reason for the absence. The condition of the apartment is also taken into consideration. Did you vacate the apartment because of a reason that makes sense, like there was asbestos or mold that drove you out, and you have an environmental report that proves that? The condition of the apartment can also be used against you in this way. I've had situations where tenants weren't there, and then there was a leak, and because they weren't there, they didn't know there was a leak, and that leak did massive damage because nobody was there to see it, created mold, leaked onto another apartment below it, and the bad condition of the apartment with nobody calling for repairs tended to prove that the tenant wasn't really there. And then the contents of the apartment. So now if the apartment isn't furnished, if it's empty, if you're just using it, if it's set up as an office and not as a home, these are other things that will be considered. And then finally, my final thing I want to talk about is warehousing. So it's really, this is where you get your pied à terre. I know I don't pronounce that in the fancy French way. I say it in the American way, pied à terre. So your apartment that you keep in New York for when you want to come and visit New York. If you're just using the apartment to come to New York when you want to see a baseball game or a show or for work, that is not going to be considered your primary residence. So the takeaway on this segment is there are lots of ways in the modern age that we have information about each other. I mean, there's very little anymore that's private. I don't even know how you would sneak around without your whereabouts really being capable of being determined. Your credit card, where you're using it. I had a case recently where we literally had to do a spreadsheet and analyze how much food the tenants bought in Westchester and how much food they bought in New York City. Literally, we had a spreadsheet where we did that. And it was pretty 50-50 kind of thing. So where you're using your credit card, where your car is driving, where your work is, social media, you're exposing yourself. So really our whole lives are kind of recorded these days. So you have to keep that in mind when you're planning what you're going to do and why you are going to do it. And that's all it really requires. I wrote this booklet because I get so many calls on this, and people just don't know even what the basic rule is. And they have no clue that all this stuff is going to be what a court is going to want to look at. And if you don't know that, you might just think, oh, my voter registration is in the apartment, good for you. But if you've blown all this other stuff, and again, if you've done it innocently, not because you're trying to scam another New York City family out of an apartment, but because you really do live in New York, but you thought you'd take that Florida tax abatement, or you really do live in New York, but you thought you'd enroll your child in school for a year somewhere else to see if they liked it. Whatever is going on, you should have in the back of your mind that you don't want to do things that would tend to make people think you don't live in the apartment. Okay, so there you have it. Remember, 29-page free, completely free booklet. I put it on my law firm website. Itkowitz.com, itkowitz.com. I would put it on the website that I'm using for the podcast, except I don't know how. I'm just going to have to ask my tech guy to give me a page. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is Learn to Live Better, a housing law podcast.